Coming to you live from Radio Cayman Studio.
For the record.
For the record. Hear from your government officials, independents, and the opposition on issues that matter to you. The record. Engage in an open dialogue between residents and lawmakers.
For the record.
The record. Informative, impartial, insightful.
This is your talk show.
1-800-534-8255. Your calls, your input. This is For the Record. And now, your host, Orit Connor.
Good morning and welcome to For the Record. Whether you're here in the Cayman Islands or if you're listening overseas via the web. And if you're listening overseas via the web or locally via the web as well, and if you're having difficulties, if you find that the content and the sound is intermittent, sometimes it may shut off for a few seconds or for a few minutes, please let us know either by calling in and we'll give you the numbers or by sending an email to us. We want to ensure that you're getting a continuous service from Radio Cayman for all of its shows. So we want to ensure that our streaming audio is working as it should be. So whether you're here in the Cayman Islands or if you're listening overseas via the web, we want to welcome you. Of course, For the Record is a show produced by Radio Cayman, its staff, and its management specifically for you, and it is geared towards keeping you abreast of issues as they arise and play out on the local, regional, and international scene. I am your host, Orit Connor, also known as OC, and you can join me on For the Record every Monday, Wednesday, and Friday, if those days are not a holiday, and if I don't have fish poisoning, which I don't plan on having anymore, at least not from Barracuda. So you can join me on Mondays, Wednesdays, and Fridays from 7:30 a.m. until 9:30 a.m. Our phone lines are always open, and there is always someone waiting to take your calls. And we always take your calls right from the get-go, from the start of the show, unless there is something that we're discussing and we want to get to the heart of the matter first. Then we will inform you as to when we will start to take phone calls. So sometimes that may happen, but 9 times out of 10, we take your calls immediately because we know some of you are early birds and want to get your 5 cents in early and then get on to work or get on to other matters that you have to deal with. So our phone lines are always open. Normally, it is Susan there waiting to take your calls, and she happily takes them. Sometimes she will talk to you. Sometimes she will just simply take your message that you want to relay to me because you may not want to talk on the phone. But if you do want to talk on the telephone, then you can call us on our toll-free number, which is 1-800-534-8255. Or you can also call us on 949-8037 and 949-6990. The last 2 numbers are not toll-free numbers, but you can still call us there. So if you have any issues as far as our streaming audio is concerned, please call us and let us know. 949-8037, 949-6990, or our toll-free number, 1-800-534-8255. And of course, if you don't want to talk on the telephone, then you can email us at For the Record. That is one word, For the Record at candw.ky. I want to remind you that For the Record is brought to you by the Auto Spa on Godfrey Nixon Way. You can receive a free vacuum with every express wash only on Tuesdays at the Auto Spa. So that can be what you can receive from the Auto Spa. We also want to remind you that you have until Saturday, the 15th of November, to enter the Auto Spa's raffle. And what you do, that is tomorrow, the 15th of November. Just bring in your coupon, which grants you $5 off a full-service wash, and be entered in their raffle. The winner will then be announced on November 18 right here on Radio Cayman. We also want to remind you that the Auto Spa also offers valet service, which means that your car can be picked up from your job or from your home and returned to you within the hour after pickup. They also want to assure you that the valet service is fully insured. Your automobile is fully insured, so you need not worry about any damage that may occur if it were to occur during transportation. That valet service is available in the immediate downtown Georgetown area, 7 Mile Beach, Cayman Bay area as well. So our big sponsor, the Auto Spa, has several deals for you. We encourage you to take advantage of those deals. Like we said in our introduction, we always want to keep you abreast of what's happening locally, regionally, and internationally. So let's look and see what's happening locally at first. Let's take a look at some of our local newspapers. Caymanian Compass, I keep calling it the Caymanian Compass. That's the only name that I know it by. The headline there, or premier, no more ad hoc management. And just to summarize that, it means that there will be one management style, one template for all government entities, including statutory authorities and government companies. We see them now operating as a government in themselves sometimes. That no longer is going to take place. One that relates to us right here in Radio Cayman, government-owned media face merger. And it talks about merging the government communications entities. That is CIG TV 20 will be merged along with Radio Cayman and Government Information Services. They will all become one entity. They have remarked they're not certain whether or not the staff of, I think it's 35, comprising all entities, will be retained. And that is in accordance with the E&Y report and recommendations. And that is something that is taking place now, even before government gets its machinery up and running in relation to monitoring and administering the recommendations that are accepted. The Premier has said in the past and continues to say that Radio Cayman, which is the people's radio station, owned and operated by you and serves you, as those old people would say, through thick and thin, through thick and thin, whether there are storms, northwesters, Radio Cayman is always there to serve you, and he has insisted and reiterated that Radio Cayman will not be sold, will not be allowed to pass into private hands, because if it does, then you, the people, will lose control and will not have one of the few things that we as Caymanians have now that we can call our own and that you so happily identify with. Another story in the Caymanian Compass, West Bay affordable housing issues linger, and it seems to indicate that at least 6 families have now vacated those premises and are into other housing arrangements. And we know in the past that Children and Family Services were vetting all of those families there to determine exactly what will happen. So that is taking place now, and we're happy to see that is taking place. Small story on the inside, local, regional, government credit card defrauded of $6,800. That has to do with the current premier and former Minister for Education, whose credit card had been defrauded. Not something that is new in terms of defrauding credit cards. You travel all over the place, and there are those people who are out there looking to take advantage, employees who will record credit card numbers and pass them on to their associates who then use them. And it seems as if the Premier didn't even know about this until it was brought to his attention after the information was provided by the Education Department based on a Freedom of Information request. Again, that is not unusual because his finance department in the ministry would take care of issues like this, and as long as it wasn't something that was used by him personally, then they would have taken care of it. And the story goes on to speak of the fact that those charges, unauthorized charges, were reversed. So the fraud was obviously acknowledged by the institution that issued the credit card, and those charges were reversed. Let's take a look at our other online paper, the Cayman News Service, and it talks about the public interest to guide cuts, and that was based on a statement made by the Premier of the Press. At a forum that took place that was done by the Society of Professional Accountants, and he basically said that the public interest will guide the cuts as recommended in the Ernst & Young report, and it will not be done just simply to favor some at the expense of others. That's a broad summary of basically what he said. And let's take a look at the Cayman Reporter, Pirates Week Parade 2014. And in the news section, implementation of disability policy going forward. And we saw in the news where that policy was approved by the cabinet last week. That was approved by cabinet. And that is going forward now. And I want to congratulate all of those who were involved in developing that policy. And that was that committee was chaired by Mr. Robert Lewis in the cabinet office, and we did have Mr. Lewis on here, as well as Ms. Shara Smith, who discussed it several on our show here. So I want to remind you again, folks, that you're listening to For the Record. I'm your host, Art Connor, and when we come back from this quick break, I will tell you who my guests in the studio who my guests are this morning with me and what we will be discussing. That's just to keep you holding there for a while. So please stay tuned to the dial. We'll be back shortly. And welcome back to For the Record. I'm your host, Art Connor, and I have as my guest in the studio this morning, we have prominent local attorney, Mr. A. Steve McPhail, and we have Mr. Chris Saunders, who's an accountant, but also was a candidate in the 2013 general elections. He was a candidate in the district of Bordentown. He's both of them. They're no strangers to For the Record. They have been on here before. I continue to have them on because of their knowledge, in-depth knowledge on particular issues. Today we want to discuss the suggestions made in the table detailing the suggested sections of the 2009 Constitution for review that was compiled by the Constitutional Commission and issued on the 14th of October 2014. Later on in the show, I will read to you the letter that was sent to Her Excellency the Governor, the Premier, the Leader of the Opposition, and the Foreign and Commonwealth Office by the Constitutional Commissioners in relation to their suggestions. So that will outline exactly, detail exactly what their intentions are as far as these suggested recommendations are concerned. There is no one locally that I know that is more in tune with our Constitution and more familiar with it than Mr. A. Steve McPhail. Not only has he been involved in terms of suggestions being made when the Constitution was being discussed, but also he has been involved in legal issues since our Constitution has come into effect. So, Mr. McPhail, I want to say good morning to you and welcome again to For the Record.
Good morning to you, Mr. Connor, and thank you for asking me to come today.
Thank you very much. We also have, as I told you earlier, Mr. Christopher Saunders, who was candidate in the district of Bordentown in the 2013 general elections. He's an accountant, but he's also well versed in many areas, and if I may say, he's a political animal as well. So, Chris, good morning and welcome back to For the Record.
Good morning, O.C., and glad to have you back. And good morning, Cayman. It's great to be here. Sitting next to Steve, I have the most respect for Steve. He has also been my neighbor for 30 years in Northwood, so I kind of grew up next door to him, literally. Right. So it's great to be here.
Thank you. Now, gentlemen, our Constitution, like others, is a living document. We see, for instance, in the United States of America, I believe that there have been something like over 11,000, pretty close to 12,000 suggestions in terms of constitutional changes. Only about 33 have actually gone through, because not only do they have to be accepted, but if once they're accepted, they also have to be ratified by the individual states. So it is a long process. And of course, their constitution, you're looking at back from some 1789, 1776, 1789, somewhere around there as well. So, we can't really compare ourselves to them to that extent, but we certainly can say that our Constitution is a living document. Our Constitution came into effect on the 6th of November, 2009. There are those who saying, you mean, it's only been in effect now 5 years and we're looking to amend it. That happens with almost all documents. No matter how meticulous you are in terms of going through it, there is always change, because there's always the need for change, because once you start to work with the document, then you start to see some of its shortcomings. As opposed to some policy issues that may have been taken and political issues that may have been taken when considering our Constitution. Mr. Macfield, you want to comment on that, please?
Yeah, I think so. And, as you were mentioning that, I was just thinking to myself, perhaps that's why the British doesn't have a written constitution, because of the problems with amending and not being able to foresee the future. As you said, when you write a contract, because that's what a constitution is a contract between the government and its people, and then some contractual things, some event come up that is not covered in the contract, and then what do? You go back to the table, go back to the parties, and then you try to get a consensus. You try to get you try to get an opinion, and then you make amendments to suit the occasion and or the event that has happened that you have no provisions in the document to cover. And this is what it seems to me that the review is all about. I think that we've had so many problems with that came about. Well, not so many, but we have a problem that came about, and I'm really happy that the Constitutional Commission has compiled these different questions and I put them out to the public for perusal, because it is very, very important. And as you have said, Mr. O.C. Orrit, that as Lord Sankey had said long ago, the Constitution is a living, breathing tree. It's like branches, and sometimes branches die, and sometimes branches have gotten too big and you have to prune them, and sometimes you have to cut out the dead branches to let other new branches come. And that's why he called it a living tree, Lord Sankey. And I think that instead of sitting around and waiting till some real crisis happens that we can't control, it's best that we try to do it. The only problem that I have with it, or it is that it is not it's not within our remit actually to do the amendments. The amendments the way the amendments have to come about are written in the Constitution, and some of them are very onerous, because it's not our Constitution really. It's an order in council. It's an order from the British Parliament. It's not really our Constitution. It's an order in council, and it says that it can only be amended with their consent. Although minor things minor things can be amended and supported, but it still has to go to the British Parliament to get the amendment there, even though the legislature might agree what should be amended. That's the problem that I have with the Constitution. And well, I guess it's not such a big problem because I know historically what happens with other constitution. I remember the Canadian Constitution too could not be amended, and in fact could not be repatriated until Trudeau came into power in the 1960s and 70s, and he repatriated the Canadian Constitution, and they can amend their own constitution now. But of course, we're not a sovereign country like Canada, nor New Zealand, nor Australia. We're an overseas territory, and therefore our any amendment is subject to what the Westminster tells us that they will accept.
Okay, Chris, do you want to add anything to that?
Yeah, just expand on Mr. Macfield's opening statement. You know, I too, I guess, always sits in amazement where the UK themselves have no constitution, but yet they push one on other people. I think part of their doctrine, I mean, unlike the United States where they do have separation of powers, where they try to at least create 3 equal branches of government, in the United Kingdom, they basically believe in parliamentary supremacy or parliamentary sovereignty. And for them, they have this belief that no current parliament can basically bound a future parliament. And even in their system, the parliament is above that of the courts. What is a little bit kind of ironic is that, I mean, you look at the U.S. Constitution that came into force in 1789. I mean, since then, 33 amendments, as you said, or could have been 27, 33, whatever. But we have a document now that is basically 5 years old. And we're now looking at making more changes than the 227 years since the United States Constitution was literally created. I mean, and what is a little bit ironic is if you look at the what inspired the United States Constitution was also the Magna Carta that came out of the United Kingdom. The Magna Carta came around in 1215, which is actually 799 years. And that is one of them that looked at a lot of individual rights. And what I have a fundamental problem with, I mean, especially with the changes that are being recommended, is that some of the serious changes that needs to be looked at aren't being looked at. I mean, the United States Constitution itself was built on individual rights, the rights of the federal government and the rights of the states. But it started with individual rights. The Magna Carta itself also looked at individual rights at the time and looking to control the powers of the king. And that is pretty much what the U.S. used as their I call it impetus in terms of pushing back a little bit on what they are on England at the time. And now we have a situation where in 2014, I'm looking at an article that was in the Cayman Observer the other day where the governor can sit down and literally wiretap, I mean, phones. And I mean the amount of power that the governor has and the government has in this day and age, I believe that is what really needs to be looked at. I mean, the individual rights in this country needs to be defended a little bit more. For me, another issue, I mean, before we get into the meat of this, is that I think it's a statement by the Premier concerning that some of these changes would be too expensive to take to the referendum. We brought this constitution in a referendum, and any major changes needs to go back to the people at a minimum. And when you're saying something is costly, I find a little bit funny where you can find $500,000 to go spend on consultant for 50-year waste management, whatever study, among all other studies that we have had, already done, but yet we can't find money to take this back to the people and educate the people properly. We have already had 2 challenges involving this constitution since it came into effect, 2. And we're not talking about investing the type of money. But I tell you what, when the government has to go to court or whoever has to go to court to defend it, it costs a lot more. So you might as well spend the money now and try to get this document right. Because failure to do so will cause serious problems inside this country.
And, speaking of that, when we look at another section of our Constitution where we leave it in the hands of 2 individuals to determine whether or not these almost literally whether or not these changes will take place, the Premier and the Leader of the Opposition. Because if we get no agreement between the 2 of them in terms of changes, as far as a referendum or any changes to the Constitution, then nothing happens. We cannot allow ourselves to be left in limbo where it is left to two individuals. To me, that should be extended to the Legislative Assembly. Gentlemen, we're going to take a time check now, and then we're going to go to the news at 8 o'clock. Folks, I want to remind you that you're listening to For the Record. I'm your host, Orrit Connor. My guest in the studio with me this morning, I have Mr. A. Steve McField, prominent local attorney, and Mr. Christopher Saunders, who was a candidate in the 2013 elections. We're discussing the Constitution and proposed constitutional changes. Please stay tuned. We'll be back after the news. Good morning and welcome back to For the Record. I'm your host, Orrit Connor, and my guest in the studio with me this morning, we have Mr. A. Steve McField, prominent local attorney, also an expert on our Constitution. Not only our current Constitution, but the history of our Constitution as well. And we'll get him to share some of that with us today also. And I also have in the studio with me Mr. Christopher Saunders, who was a candidate in the 2013 general elections. He was vying for a seat in the District of Bordentown. We're here discussing the 14th of October 2014 table detailing the suggested sections of the 2009 Cayman Islands Constitution Order that has been compiled by the Constitutional Commission. And I will start by stating that on October 14th, the Constitutional Commission sent the following letter to Her Excellency, which I mentioned earlier, the Governor, the Honorable Premier, the Honorable Leader of the Opposition, and the Joint Team Leader of the Overseas Territories Directorate in the Foreign and Commonwealth Office. And it reads, following on from our previous correspondence, the Constitutional Commission wishes to take this opportunity to inform you that it has completed its review of the Constitution by examining it section by section. In addition, while it has not engaged in a public consultation on the subject, the Commission has included comments received from various other parties. During its review, the Commission identified several sections which are sufficiently important to warrant being considered for amendment. There are various reasons for the identification of these sections, including, without limitation, ambiguity or uncertainty. The sections detailed on the attached table are those with or without the need for a referendum, and it wishes to make it clear that the review was carried out on a limited basis only and not for the purpose of considering any form of constitutional advancement at this time or to propose amendments it felt could only be achieved via a referendum. That part there is important, and I'm going to read that again to you, right? It's extremely important. It says here, the sections detailed on the attached table are those the Commission believe are capable of being dealt with without the need for a referendum, and it wishes to make clear that the review was carried out on a limited basis only and not for the purpose of considering any form of constitutional advancement at this time or to propose amendments it felt could only be achieved via a referendum. So there are things in this table, these suggestions, that do not require a referendum. So when we hear our politicians talk about the fact that they don't want to look at this, they don't want to consider it because they don't want to have to go to a referendum, and some may not want that for political reasons, others may not want it because of the additional costs that will be incurred by the Cayman Islands government. Like some of them really care about the cost of the Cayman Islands government. We have seen some of them cost the Cayman Islands government more than what it will cost in a referendum for reasons other than the public interest. So We are not going to accept, and I suggest to you that you shouldn't accept the fact that there are amendments that are necessary to ensure the tidiness and to remove ambiguity from our Constitution that should be dealt with now. You should not accept that argument, and in not accepting that argument, you should read the document for yourself. You should read the letter that was issued by the Constitutional Commission, and you should go over the table like we're going to try to go over here. Today, we're not going to be able to cover all of it, but we're going to do as much as we can. It says the Commission fully understands it is ultimately for the Honorable Premier and the Honorable Leader of the Opposition to determine whether, and if so, when, to take this matter forward in accordance with the tenor of the letter of entrustment dated 10th June 2009, a copy of which is attached. That letter of entrustment was issued by the Foreign and Commonwealth Office when our Constitution was approved and given to us. The letter also goes on to state that the Commission strongly recommends that the Premier and the Leader of the Opposition establish a committee to consider this matter in further detail, and if such a committee is established, the Commission would have no objection to being included in the membership thereof. In closing, the Commission wishes to indicate that it considers the contents contained in the attached to be in the public interest. I repeat, in the public interest. And therefore, in 1 month, the Commission shall post these documents on a website. So again, it is in the public interest that these recommendations have been made. Gentlemen, let's look at the table. Let's start to look at the table now, unless any of you want to comment on what I have said earlier in relation to leaving it in the hands of two individuals to determine whether or not we should be moving forward as far as amendments to our Constitution is concerned. What have we done about the members of the Legislative Assembly? Where does their responsibility lie, especially their responsibility to their constituents, Mr. Macfield?
I think that is one thing that I find wrong with the Constitution, with the whole system as it is. Amendments and changes to the Constitution, why should it be left to two people, really? Why should it be left to the Premier and the Leader of the Opposition? The Constitutional Commission reviews and amendments should go to the Legislative Assembly. The 18 members of the Legislative Assembly should vote. It should be a 2/3 majority vote on whether they will accept them or not accept them at all. I mean, just suppose the Leader of the Opposition does not accept them and does not respond to the Commission's letter and review. What happens then? What happens then? Does the proposed suggested review of the different sections of the Constitution just die and fall away? I don't think so. They're going to still remain there because that's a fact of history, and I think it should not be left to just the two people. I think the suggested reviews should go to the whole assembly, and the assembly should vote as to whether they want to bring these reviews into effect or not just two people.
And we have seen, I believe that the Leader of the Opposition has written to the Chairman of the Constitutional Commission and put his views forward.
I think he has said that he doesn't have time to do it now, or this is not the time. There are other pressing matters that we have to deal with. But there should be no more pressing matters than the Constitution. And
yes. Like Chris has mentioned earlier, we have seen two challenges so far as our Constitution is concerned.
And I have been involved in all two.
And you've been involved in all two. And important challenging, costly challenges as well.
That's right.
Clarity that, for instance, had the returning officer and the elections office had in relation to the Constitution other than our interpretation of it and the legal advice that we would have gotten on it, it would have certainly made life much easier for the returning officer in those electoral districts where questions may have arisen in relation to an individual's qualifications for nomination.
That's right. You remember the first case was Mark Scotland and John in Bodden Town, and you remember that the case turned on the question of whether or not they were out of time, that the petitioners were out of time when they brought the matter before the Grand Court. A similar case was brought in 1962 against Mr. Jim Bodden. And you remember in the case that I was involved in, the objectors brought the action by summons before the Grand Court. And of course, the Constitution is very clear that any challenge to a legislator has to be brought under the elections law. And the 1962 case that was brought against Mr. Jim Bodden, they also brought it under summons. Now, the case was heard by Mr. Justice Moody in the Grand Court, and the lawyer for the Mr. Jim at the time was Mr. Paget Brown, and he was arguing that the objectors had brought the action by the wrong way, the wrong suit, and the Grand Court still heard it anyway. Now we know today that case is wrongly decided, or had been wrongly decided. And the same thing was in Mark Scotland's and John John's case. The Chief Justice ruled that the objectors were out of court because they had not brought the objections by way of petition, and that they could not bring it by way of summons, because summons is where you bring matters in persona, and the petition is like it's for the whole community. But when you are objecting to someone's being elected to the legislature, it's not just it's not personal.
Chris?
One of the things, just looking back at this whole, where the premier and the leader of the opposition can, I guess in essence, decide what goes forward from a constitutional standpoint, it is the inconsistency with the approach I also have a problem with. Last year, we had both the premier and the leader of the opposition at that time saying to the governor, listen, we had a third constitutional crisis where we ended up in a minority government for a few months. And in that situation, you had both the premier and the leader of the opposition literally wanting early elections. So, yet we didn't have it. The governor instead went with a minority government at that point. So, why is it then you can have these two gentlemen decide what constitutional changes should go forward and how it should go forward, but yet if these two gentlemen come back and say, you know what, let's go back to the fresh, have a fresh polls or something, you can't have something like that. I mean, at what point do you have some level of consistency where the two agree? No, I believe that within our democracy, they should have a situation where, in some situations, even early elections, if both the leader of the opposition and the premier agree that there should be early polls, I think that is something that the governor should just basically take on recommendation when you have people inside the house looking for something like that. But that is not something that they're willing to consider. But yet, at the same time, on matters relating to the Constitution, which is much more serious and impacts the public more, they're not given that level of discretion. I mean, and we need to have some consistency. And I think maybe England does have it the right way in the sense of not having a codified constitution like the United States, but literally having precedents set in terms of how it is that they're looking at things. You know, so it is definitely a lot of work. And I mean, kudos to David Rich and his team for bringing forward these recommendations. And as I was going through some of these last nights, I literally said to myself, one, I feel much better now not voting for the 2009 Constitution. I did not vote for it. I have no problem telling people I didn't vote for it. I read the document and there were just too many issues inside of it. And on top of that, the government at the time did not convince me what was wrong with the 1972 Constitution, why we had to basically have this change. So and I'm looking at this, 34 amendments, and probably God, He knows how much more, or this maybe even been edited, how much more amendments could be on the way in such a short period of time. Clearly we have a flawed document, and it requires a lot of work to get it right. And it has to be done, very quickly, because people need to ultimately understand this document governs how they are treated and also how the government must be run. And one of the things, that is missing from this document, the essence of it, and one of the things I do admire about the U.S. Constitution is that pursuit of happiness. And what we have right now is that there's nothing inside it that really protects the essence of people's freedom, and more importantly, even that of economic freedom. Looking at one of the changes on the for Section 19 on the education, that is very broad in its sense, and I can understand the context in which what they may have been trying to say, but you have a policy here, so just to read it there. Government shall seek reasonably to achieve the progressive realization within available resources of providing every child with primary and secondary education, which shall, subject to subsection 3, be free. Now, we have an immigration policy that basically says to expatriate kids, you need to go to private school. The law doesn't say Caymanian or non-Caymanian, it says every child. So now is a situation now where, these are the kind of stuff that really needs to be looked at. And it is a valid point in terms of what is supposed to be achieved from this section. And what I would have liked to have seen more within this document is more freedoms being pushed with people, and on top of that, more economic freedom. Because what is really stressing Caymanians right now, beside the high cost of living, is also the lack of opportunity, and also where we as a country going. And this document is at least supposed to provide some framework where we as a people would like to go. And the problem with this document, in beginning, it was pushed by politicians. It was developed by politicians and not the people.
Okay, we're going to take that point up when we return. And I'll have something to say in relation to that as well, because the pushing was done mainly by the United Kingdom, because they had an agenda as well. Folks, I want to remind you that you're listening to For the Record. I'm your host, Dorit Connor, and my guests in the studio with me this morning, I have Mr. A. Steve McField, prominent local attorney. We have also Mr. Christopher Saunders, who was a candidate in the 2013 general elections, and he was vying for a seat in the district of Bordentown. I also want to remind you that For the Record is brought to you by the Auto Spa on Godfrey Nixon Way, and you can receive a free vacuum with every express wash on Tuesdays at the Auto Spa. Please stay tuned. We'll be back shortly. Good morning and welcome back to For the Record. I'm your host, Dorit Connor, and my guest in the studio with me this morning, I have Mr. A. Steve McField, prominent local attorney and an expert on our Cayman Islands Constitution, not only the current one, but the history of our Constitution in general. And we also have with us Mr. Chris Saunders, who's a CPA, but also, and you may question, what does a CPA know about our Constitution? Well, he's also, like I said, a political animal, and he was a candidate in the 2013 elections, vying for a seat in the district of Bordentown. Before we get into the discussions again, gentlemen, I just want to clarify something for our listening audience. In the letter, the Constitutional Commission said that in closing, the Commission wishes to indicate that it considers the contents contained in the attached to be in the public interest, and therefore, in 1 month, the Commission shall post these documents on our website, www.knowyourconstitution.ky. And of course, this document came out before the 1 month time, which would have been then the 14th of November, which is, I believe today is the 14th, is it?
Yes.
Today's the 14th. So here is what, on the 30th of October 2014, the Commission became aware that the letter and table was released to the Caymanian Compass, and as such, the Commission informed the other relevant parties that the correspondence would be published to its website, foregoing the 1 month waiting period it had initially set. So that is why you were hearing about this and you were able to access this document before the 30-day period before the 14th of November, that is because it had been released to the Caymanian Compass earlier. It doesn't say whether or not it was erroneously released to them, but it was released, and as a result, then it became a public document. So that is why. Let's start to look at the document itself, Mr. McFeel. 1 through 4. Numbers 1 through 4 in the table really deals more with the Bill of Rights than anything else.
Yes.
And I will give you an opportunity to comment on them. And one that is really, really right up your alley would be the Fair Trial, Section 7, subsection 2A of the Constitution, the Bill of Rights.
Yeah, the Fair Trial, Section 7. When you look at Section 7, let's quickly get to it here. When you look at Section 7, it says everyone has the right to a fair and public hearing in the determination of his or her legal rights and obligations by an independent and impartial court with a reasonable time. And then the commissioners, the commission has a dispute with Section 7.2a, which says everyone charged with a criminal offense has the following minimum rights: to be presumed innocent until proven guilty according to law. I think the commission has some problem with that, because if you are presumed innocent according to law, then why is it that there's a law that says that if you remain silent, then that can have adverse effect on you when you go to your trial. It's contradictory to the Constitution. Really, that law is contradictory to the Constitution. So if you presume innocent, if to be presumed innocent until proven guilty according to law, it means then that you do not have to give any statement. You do not have to say anything about the cases. It's the Crown who's bringing it. Should prove your guilt, and that you presume innocence, and that is the reasons why you have the bail law, which you're entitled to bail, so that you're not incarcerated in detention, waiting your trial, because you presume innocent, and the detention should only happen after you have been convicted and you have a sentence by a court. So why is it then that you have to give up your rights to tell the police something or to speak to the police to prevent an adverse comment against you at your trial, and adverse inference against you? It does not make sense. And I think the commission has a point there, and that needs to be clarified.
Mm-hmm. One of the things that I know, one of the exercises that the government went through, and we all government entities were asked to do so, to look at all of their legislation, because we then had to ensure that the legislation was consistent and not in violation of the Constitution that was coming into effect. And where those laws were found to be, in violation of our Constitution, then the necessary changes needed to be made, with them.
Yes, and when you look at Section 16. That is the reverse discrimination clause.
Non-discrimination.
Yes. Clause. It discriminates in favor of Caymanians, and it's very important. It's very important because it says, subject to Section 345 and 6, government shall not treat any person in a discriminatory manner in respect of the rights under this part of the Constitution. And in this section, discriminatory means affording different and unjustifiable treatment to different persons on any grounds such as sex, race, color, language, religion, political or other opinion, national or social origin, association with a national minority, age, mental or physical disability, property, birth, or other status. And then no law, and this is the one, and this is the part of that section that the commissioners are talking about, subsection 3. It says, no law or decision of any public official shall contravene this section if it has an objective and reasonable justification and is reasonably proportional to its aims in the interest of defense, public safety, public order, public morality, or public health. And then the commissioners is saying, they say this section lists the instances where its subsection 1 does not apply, but does not indicate that subsection 3 does not apply. The question, therefore, is whether, regardless of the section explicit exclusions, must subsection 3 be abided by. I don't think so, because the Constitution is very silent on that, and it's very complicated, because it seems here that when you look at subsection 3, it says no law or decision of any public officer shall contravene this section if it has an objective and reasonable justification and is reasonably proportionate to its aims in the interest of defense. Well, a public official can contravene this section if, in his opinion, it is in interest of defense, public safety, public order, public morality, and or public health.
Just about everything.
Just about everything. And it's not defined. And what the commission is worried about, do we have to abide by that, or can we just ignore it? And I don't think so, because it does apply. Mm-hmm. And when you look at this section here, and you go on, because it says if you look at section 5, it says nothing in any law shall be held to contravene subsection 1 to the extent that it requires a person to be a Caymanian or to possess any other qualifications, not being a qualification specifically relating to any such description of grounds as is mentioned in subsection 2, in order to be eligible for appointment to any office in the public service or in a discipline force or any office in the service of a local government authority or of a body or corporate established directly by any law or public purposes. So what that section says, that what this section says, that the government can pass any law that says a qualification for a job in any of those places that I just mentioned, that you have to be Caymanian, and it's not discriminatory. But when you look at subsection 3, it says that no law or decision of any public official shall contravene this section, but it doesn't say whether or not this section applies to everything else. And so that is some of the problems with the Constitution. And the one that really I'm interested in mostly is section 19.
Lawful administrative action.
Yes.
Mm-hmm.
The Constitutional Commission says that supporting legislation may be necessary to enforce this section. In South Africa, the Promotion of Administrative Justice Act 2000 was enacted, giving effect to the right to administrative action that is lawful, reasonable, and procedurally fair, and to the right to written reasons for administrative action as contemplated in Section 33 of the Constitution of the Republic of South Africa, 1996, and to provide for matters incidental thereto. Now, that is a very, very important section. I think that's one of the most important sections on this first list here, because, for instance, when you look at the Immigration Appeals Tribunal, mm-hmm. under the new immigration law, the Immigration Amendment Law number 2 of 2013, it takes away the right for a person to go before the tribunal to plead his appeal. It says people shall not be heard in person. Only the grounds of appeal and the written grounds of appeal will come before the tribunal. Now that cannot be reasonable and be fair. And then the tribunal does not actually give you any reasons for its decision. All it really tells you is that it says to you that you have not made out sufficient grounds of appeal, and therefore your appeal is lost. But it doesn't give you any reasons why all the stuff that you put forward, they have rejected it. So not only that, it's an appeal body. It's like a court, and it should be in the open, in the public, in the interest of transparency. And reasonableness, it should be in the public's. The hearing should be in the public, so that the public could be able to go and listen and to listen to both sides. Mm-hmm, mm-hmm. And the thing that really bothers me is the new amendment to the immigration law, the Immigration Amendment Law number 2 of 2013 takes away the right for a person to go to before the appeal tribunal to prosecute his appeal. Now, how could a tribunal be acting fairly and procedurally fair without you coming before it to persuade them the reason why your argument should be accepted by them when they are going to take adverse decision against you?
You know, Mr. McPhee, that brings another thing to mind which is absent within this Constitution. When you look at some of the appointments that we have to some of these boards, these are very serious appointments, and at a minimum, some of them should be subject to legislative approval. I mean, in the U.S., you have Senate hearings for powerful positions.
Exactly.
I mean, and yet we have just most of the time people get together, they appoint this one or throw this one onto the board as some kind of political favor or something, and these people wield immense power. I mean, I can tell, I sat on the immigration board before, and I mean, some of the decisions that we make, even at times that I sit back and ask myself, should this be a decision given to a group of, let's be honest, politically appointed people? I mean, you're talking about people's lives, people's livelihood and all that kind of stuff. And for people who who are not accountable to the people to be wielding such authority, it is wrong. It's wrong in a democratic society.
Gentlemen, earlier, before we went to the commercial break and the time check and the news, I mentioned the fact that there were motivations for the United Kingdom to ensure that we got a new constitution. They did it in all of the other overseas territories. We saw where Turks and Caicos got a new constitution, and we saw what happened with that. We saw the United Kingdom government eventually rewriting the constitution again, and we now see the Turks and Caicos Islanders now positioning themselves to have it rewritten again. And the UK went so far as to rewrite it to the effect that they're allowed to bring charges, prosecute the former premier and his former ministers, and to deny them the right to a trial before a jury
of their peers.
Their peers. But the United Kingdom government, bear in mind that they are still answerable to the United Nations and the group of 24, the Decolonization Committee, and it gives them an opportunity to say, here is what we have done. We have allowed our overseas territories to make constitutional advancements by giving them an opportunity to rewrite their constitution. We missed the golden opportunity. Despite the fact that we did take advantage of what was given to us, we missed the golden opportunity. How did we miss that? Number one, we did not go into the constitutional negotiations unified. We went in there with one side vying for a new constitution and another side deciding that we don't need a new constitution now, we don't support it, but at the same time, they were able to put their 5 cents in where possible. And one example would be the district councils. District advisory councils, where when you look at it, you see it is more of an afterthought than anything else. But we lost a good example, and what the people of this country need to understand and need to accept is that we should not allow our Constitution to be used as a political football. By no side. It should not be allowed to be used as a political football, because this is a contract between the people,
that's right,
and our government. This is a contract. The government, the politicians should not be able to dictate and to determine exactly what is in there, because it is good only for their purposes.
When I told my wife I was coming on the show, she said to me, Chris, make sure you behave. And I mean, you mentioned a while ago when you guys talk about we the people. I mean, that is the opening line for
The American Constitution.
we the people looking for something, better. When you look at the Constitution of the Cayman Islands, which it starts out, the people of the Cayman Islands recalling the events, yada yada yada. But then it comes down to who are loyal to Her Majesty the Queen. I can be honest with you. I don't know that woman, and I got nothing against that woman. I think she's a nice, from what I've read. I cannot be loyal to somebody I don't know. But I can tell you who I do know. I do know the people of the Cayman Islands. And the only person I'll ever be loyal to will be the people of the Cayman Islands. You start off a document telling me to be loyal to somebody I don't know. How much interest do you think I'm going to have in terms of going down? I mean, I'm being realistic. I can speak for my generation. Like I said, I don't have nothing against Her Majesty the Queen. Like I said, I think she had a wonderful life. I mean, I think what she did during World War II and everything was nice. Maybe working as a nurse or something. But I can't be loyal to nobody else but the people of the Cayman Islands. And you're going to ask me to sit back and to push or promote something, because there's actually a part inside this Constitution which I know if I was elected I would have wrestled with. I think it goes back in saying that no one can take an oath that they basically don't want to take. Of course, if it's like defense or the kind of way a public official have to do it. But I mean, to go up there and swear an allegiance to somebody that I don't know. I mean, these are, as you say, going back. Even if you're going to put it inside there, put in the people of the Cayman Islands. Put something for the Cayman Islands inside there, other than swearing an allegiance to a foreign power or a foreign entity. It is little things like these, and this is an opportunity now for us to sit back and get this document right. Mm-hmm. People need to understand this is our individual rights. We now have a governor that can run around and tap people's phones at will. I mean, no court, no nothing. I mean, the powers that the governor have. In this day and age, I don't want to use the word criminal because it may be a little, but it can't pass a test on no international standards. None. But yet, no one seems to complain about that kind of stuff.
Mm-hmm. And folks, we had one of the foremost experts on Constitution, Sir Jeffrey Joel,
Yes.
I remember.
Alongside us, advising us, a UK citizen, a UK national, advising us on our Constitution, that we, and in a sense, he's sitting there with us, and the representatives from the Foreign and Commonwealth Office and the Minister for the Overseas Territories on the other side of the table. And he's there advocating for us, advocating on our behalf. We used him to the maximum, that we could. But at the same time, he was subject to whatever was accepted by our political leaders. And when I say our political leaders, I include, the leader of government business, at that time, as well as the leader of the opposition. He was subject to whatever recommendations they made. When we look at our Constitution, as far as all of the overseas territories go, and some industrialized countries as well, we have in our Constitution the protection of our environment, something that was new to our Constitution. And I hope people take note of that as well. And those environmentalists and those people who feel that our environment is being threatened to a certain extent, to know that there is some recourse, some legal recourse that you have available to you in the form of our Bill of Rights.
Yeah, but I mean, look at the ladies, the West Bay ladies against the Dart Road and pretty much a runaround that they're getting. Listen, people need to understand. When you go up against a state or you go up against a government, you're going up against an entity with a lot of resources. I mean, financial resources. To bring many of these challenges requires a lot of money. I mean, and a lot of people do not have the wherewithal to challenge some of these issues. And what I admire about Mr. Macfield, and much to his own personal sacrifice, because Steve could have been one of those that could have done the right thing and become very rich. But he has always been an advocate for the average person. I've always admired that about him. But for the amount of lawyers that we have in this country that have remained silent on so many of these issues that are wrong within our Constitution, it is an indictment against many of them in that field in terms of what is that they can contribute. These are the people with the legal minds. And every single time they're supposed to stand up, it is the same people, like Mr. Macfield, that is pushing these issues to the people, much again, like I said before, to his own personal detriment, because people are going to sit back and say, well, we don't like how Steve sound, Steve do this or Steve do that. But this is what is needed. What we have had in this country for too long is nutless people that lack the testicular fortitude to really push our people forward. And this is the reason why today so many Caymanians are suffering, because we have had poor leadership for many decades. People who do not want to challenge the status quo and people who don't want to push the envelope. People need to remember that every single thing that stresses people out, someone profits from it. If it's your light bill, your gas bill, your supermarket bill, your health insurance bill, your mortgage, someone makes money from what stresses you out. You do not get, as the Americans say, the pursuit of happiness by having nice people. Nice people do not get things done. What you need is effective people, people who can push it and go forward. This document, as you said, was something that was pushed by the UK politicians to check a box that they have basically complied with all of these different conventions that they have signed upon without very little regard. And then the local politicians we had jockeyed for position, took advantage of it, and stick in what it is that they want. The district council, the UK system of the Westminster system is based off a bicameral system, 2 houses, an upper house and a lower house. Where is the House of Lord, the House of thing there? What we have is politicians in this country who want every single chance to hold on to power. You cannot. In this day and age, the power must be with the people. And more importantly, the people need to understand that the power needs to be with them. And that is where sometimes I can't reconcile. When people talk about the government this or the government doing that. We are the government. But we have now turned the government into a separate entity. How can you expect to move a democracy forward? When you look at referendums, the UK will tell you the referendum is an American phenomenon. We don't believe in that. They very rarely have referendums, and when they do have referendum, it's for big items. In the States, they have referendum for every single thing. Whether they want to legalize pot or charge more taxes or something, that's the way in which they work. But we, the people, need to start demanding more participation in this process and stop leaving it to the 18 people that are elected up inside that house. We need to start getting involved.
For instance, district councils, as you were saying, Mr. Connor, are it the now sitting premier, when he was a leader of the opposition, he was against the district councils as it's stated in the Constitution, because he said they were only advisory and not elected. But I don't see that as part of one of the commission's suggested sections to review.
Right. And like I said, being, there, in the constitutional discussions, district advisory district council, it was a compromise that was made at the end of the day. That was a compromise between the government and the opposition at that time. That's why we don't see any substance to it. And what I was doing some research the other day, and what came to my attention is that the section on the district councils, what happens if we go to single-member constituencies?
Yes.
Do we then need advisory district councils for each of those
Not really.
constituencies?
We would not need them then.
Or do we leave something in our constitution that still retains and identifies the districts that we're divided into: Sister Islands, West Bay, Georgetown, Bontown, East End, and North Side for certain purposes, and then for other purposes, then we look at the single-member constituencies. We're going to follow up on that. This break will give us an opportunity to do a little research and to discuss that amongst ourselves. We are going to a time check now, and we're going to the headline news, folks. I want you that you're listening to For the Record. I'm your host, Dorrit Connor. My guest in the studio with me this morning, we have Mr. A. Steve Macfield, prominent local attorney and constitutional expert, and we have Mr. Christopher Saunders with us. Please stay tuned. We'll be back shortly. If, and some people will say not if, when, we go to single member constituencies. What happens to the advisory district councils? Do we then need 18 or 19, depending on how many constituents we have, or what happened? My view of it is that we're going to have some constitutional amendment to change that. So we're going to have to go there at some point in time. And if we're going to go there, we may as well deal with those things that need to be dealt with.
Yes. And there's another point that I want to bring up today, and that is Section 124(2)(a) of the Constitution. I would like to bring that up.
Okay. While you look for that, Mr. McPhail, we have one caller on the line, so we're going to take that caller now. Caller, good morning and welcome to For the Record.
Good morning, Mr. Connor. How are you today?
I'm fine. How are you doing?
I good. Glad to hear you back.
Thanks. I haven't seen you since the fish poisoning, actually.
I was trying to stay away from you.
You may need a microscope, to see me. After that, I've lost so much weight.
I'm keeping my distance from you for a while, because as you know, I had the fish poison a couple of weeks before you, so
exactly.
I don't want to even come in contact with you.
But not as severe as mine was, right?
Yeah. And also, good morning to your very knowledgeable guest you have there this morning.
Good morning.
Morning.
Yeah, I got two questions, and they're for Mr. McPhail. And Mr. Orrit, before close going to the break, he introduced Mr. McPhail, as I know him, as a local attorney, and then he mentioned constitutional expert, which I'm also aware of his knowledge of the Constitution, and privately, conversations, and publicly on the radio. He's one of the only voice I hear out there educating the public.
That's correct.
My question to him is if he has so much knowledge of the Constitution and the Cayman history, political, socially, the overall history of Cayman, why is it that he is not a member of any committee that do the Constitution, or some consultant to whoever that want to make these changes to the Constitution? And the next question is, him being a local attorney and being a hotshot attorney back in the day, better than most of the guys that I know came to the island that wasn't no household name attorney, and now I see a lot of them are judges in the court, and Mr. McPhail have not become a judge, not a QC, and because he's local and know they make up of a lot of family, I would figure even make him why is it he not a juvenile court judge, where he'll know where the juveniles come from, their background and all that sort of stuff, because I know a lot of times when they're sentencing, a judge will wait for a social report to make his to use his discretion, I would say, for sentencing. So Mr. McPhail, being local, he would not have to depend too much on the social report. He would know right off the background of the individual and how to deal with cases like that. So that's the question. Him not being involved in the Constitution, and why is it he not a QC or a judge in the local courts?
Okay, thanks for that.
Great question.
Those questions. And Mr. McPhail, you want to answer them, or you want us to give her opinion?
Well,
You want me to answer it?
well, I'll let Chris answer it, but I will say simply that from the beginning, I guess everybody knows that I'm not an establishment person, and I think that followed me all my life up until now. At my age now, I have never been an establishment person, and therefore I was not someone that my persona was not some persona that the establishment would push forward. So perhaps, and that's what I have to say about it personally. I know that most of the people that I have went to school with, and if I may blow my own trumpet, I was a very good honored student, and in all the institutions I've been to, and all of them have surpassed me. Even some of the people I work with are now here as judges and court appeal presidents in different places and DPPs and everything, the QCs, and I think I'm the only one among that whole lot of people that graduated in England during the Silver Jubilee that is still beating the streets, as I have said. And that's why sometimes when they come here and they ask for me and they come for the conventions or the meetings and they ask for me, I don't meet them because I don't really want them to see what has happened to me, because they thought I was going to be very important in my country when I came back, when I was the least important mostly.
You know, it is one of the things that has always bothered me about our people. When you look at people who aren't afraid to speak up, to say what's on their mind, people need to understand that a lot of people died to give us this right. And I can tell you, even myself now has been a little bit more outspoken now in terms of going public with some of my own personal opinions. I mean, I can tell you, I have seen where there have been attempted victimization. And I use the word attempted because I like the fact that some people still have to hide and do what they do. And they can't come to my face with it. I actually take joy from that. And when we have a son of the soil who has spent decades serving the people of the Cayman Islands, I mean, in some cases for free, because there's a lot of free legal work that Mr. Macfield also did to help people. And the only thing you have to show for it is the thanks of an ungrateful nation. I'm going to tell you one thing. It does not push a lot of people to want to go for public service. Serving your country and serving people is a noble cause. It takes a lot out of people personally. You lose family time. And sometimes, like I said, even financially, you lose. And the way in which we treat people who are not afraid to speak up, it says something about us, the people, that we are wrong. I mean, Mr. Macfield is one of them that has been victimized literally for years. And when you look at the amount of QCs that we have in Cayman, and how many of them are indigenous Caymanians, we need to sit back and say to ourselves, but wait a minute, I think it's only one that we have there that is indigenous, a QC that's indigenous. Of all the QCs we have in Cayman, only one. And Caymanians don't believe, I mean, we don't believe that we're good enough to have more QCs that are indigenous. I mean, I'm going to tell you something. We really need to start taking a check of ourselves.
Reality
and
check, yes.
People, and I go back to my point again. I mean, some people come and say to me, Chris, are you planning on running in the next election? And I can honestly say to people, I really don't know. And the reason why I can say that is when I look at what it takes to get elected, I mean, you just show up to parties, walk around, visit people, eat from pots, and just, oh, you're doing, or your mama doing, that kind of thing. You get elected and you basically just sit on your butt for donkey years, do absolutely nothing, rack up a big pension in the process, and the people in Cayman are worse and worse and worse every year. I mean, how can people go to sleep knowing that? You there's so much you can do, but yet you just take care of yourself and to hell with the people. And then for people now who are standing up like Mr. Macfield for the people, they're being victimized, they're being called troublemakers, they're being called radicals. But I'm going to say this much. If you think I'm radical, go and speak to some of the younger people coming behind me, because I'm going to tell you, even I am afraid of them when I listen to how they speak, because they do not have as much patience as me. And I can tell you one thing, I don't consider myself a patient person.
Okay, thanks. We have 3 callers on the line, so let's take those callers now and see what they have to say. First caller, good morning and welcome to For the Record.
Good morning.
Good morning, how are you?
Good morning, ma'am.
Morning.
I'm very grateful, and I hope you gentlemen are all the same.
Thank you very much.
I'd just like to say that I actually was taking a little walk, but I never got to hear all the program this morning. But I'd just like first to say that Mr. Macfield could come on that radio or any other show or whatever, and I know he would have the public listening to him all day long. I mean, he's just one person that you never get enough, hearing of. But I'd just like to say this, that we really have to take a good look and see who have been keeping the Caymanians down. And when I say Caymanians, I'm going to be very blunt, and I mean the born Caymanians, those that have 3 and 4 and 5 generations here, and it's so sad to see someone of Mr. Macfield's caliber, experience, and the knowledge, and so patriotic to this country, his country, our country. And I just like to say, I mean, when you look at it, we have another Jamaican judge, Grand Court judge, that just came here again. We have to look at it really carefully and to really be honest and say, who is it that is keeping us down? You know, and to be frank, and I don't care who is offended by it, but I just like to say that, Mr. Macfield, you have contributed so much to this country, and may God continue to bless you. And I know your children are being blessed. So just keep up the good work and know that you have a lot that are behind you and are grateful for your contribution, and that you still continue to contribute to this country, and may God bless you, and you all have a good day.
Thank you, ma'am.
Thank
you
you.
very much for
Thank
that.
you very much, caller. Next caller, please. Caller, good morning and welcome to For the Record.
Yeah, good morning, O.C.
Good morning. How are you doing?
I'm glad you're not hurting your knees, not hurting no more.
Thanks.
But good morning to Steve and Mr. Chris.
Good
and,
morning, Rupert.
Yeah, I want to say this, that what that lady just called in was pretty much what I was going to talk about. Because, you know, it's a shame that Caymanians like Steve, that, I mean, we all have our ups and downs and our you know, none of us are perfect. But I can tell you that Steve has contributed a lot to the island. I believe that, you know, over the years, in terms of he's always there, you know, in the middle of things when you need him. But my question is this, and I asked a question some time ago to one of the sitting judges or something. And I asked, why is it that we don't have in Cayman a Caymanian judge? Because, you see, a judge don't have to go to school to be a judge, you know. If you're a lawyer, that's how you get promoted. You go up in there. They move you up in the ranks. It's like a QC. A QC has little to do with how good you are, but if you have served the Queen and been with the Queen for so many years, and you've been a loyal subject to the Queen, they can promote you and these kinds of things. But my question is this: why don't we have a judge who is a Caymanian? The answer I got was that Caymanians could not be unbiased because they know everybody. Now, I never heard such a lame excuse in my life. The fact is, I believe they don't want Caymanians because other people are getting too much promotions and moving in here and have taken over. That's simply what it is, in my opinion.
Okay, thank you very much,
Thank
caller,
you.
for that.
Thank
And
you, caller.
Thank
we
you.
will certainly address that. Folks, I want to remind you that you're listening to For the Record. I'm your host, Stuart Connor. My guest in the studio with me this morning, we have Mr. A. Steve McFeel and Mr. Christopher Saunders. We're discussing the proposed constitutional changes, some minor, some may be considered a little bit more major, but we're discussing them. Please stay tuned. We're going to be back shortly. Good morning and welcome back to For the Record. I'm your host, Stuart Connor. My guest in the studio with me this morning, we have Mr. A. Steve McFeel and Mr. Christopher Saunders. We have one caller on the line and we're going to take that caller. But before we take that caller, we just want to bring it to our audience's attention that we do, one of the QCs, Caymanian QCs, is
Mrs. Norvik.
Mrs. Norvik, Eileen Norvik. And
Yes.
we also have a local magistrate, Mrs. Philippa McFarlane Ebanks.
Yes,
you know, she
and we
is.
also have Mrs. Wong. She was to be Mrs. Wong.
Angeline
Angela,
Hernandez
and
as
she's
well.
a magistrate.
Yes.
And I think, that's right. They're the two.
And Philippa grew up down the road from us too, actually.
Yeah. Okay.
Norward, yeah.
Let's take the caller now. Caller, good morning and welcome to For the Record.
Hello, good morning.
Good morning.
Good morning, ma'am.
Yes, this is Suzanne Boswell calling.
Hey there, how are you? I was thinking about having you on here, you know, and I haven't, you know, dismissed it totally yet, but, you know, I would have to look at your availability and, you know, whether or not you'd be able to come on, but I'm sure you should be able to.
Well, I'm a citizen first.
That's right.
Good.
I just wish to say good morning to the esteemed panel.
Thank
Mr.
you.
Maxfield, who I will agree has contributed more than anyone else in the discussion on constitution and constitutional reform and constitutional awareness. And I am pleased to see that Mr. Saunders is, in his own way, being an advocate as a private citizen. I just wish to touch on the fact that I think part of what is missing in the Cayman society is a passion for advocacy. Advocacy is not limited to lawyers. Advocacy must come from the public. And one of the concerns that I had when we were doing the constitutional reform was the actual lack of advocacy on the part of the public who were passionate about subjects. It is no longer any good to have the front porch discussion or to rely on our elected representatives to push through what we perceive to be the public agenda. And I think that the district council situation is a classic example of something that was born out of really and truly public desire, grassroots desire, to have a greater say in government and how their districts are managed.
Mm-hmm.
And they were able to get as far as to at least get a single mention in the Constitution, but where they were not galvanized enough was to identify a model that they would like to see. So what happened, in my view, was a hijacking of the exercise by the political arm of government, who, quite frankly, were not too desirable about seeing advisory councils whereby citizens or residents have a greater say in how the districts are run.
Mm-hmm, mm-hmm.
So we have a law which, in my view, represents very little the desire of the public. And I really feel that if the public are passionate about reclaiming this aspect of the Constitution and their ability for more horizontal involvement in government,
yes. Mm-hmm.
then they must review the law, they must come with a proposal, and they must advocate for it in the same manner and fashion that they advocated for it to be at a constitutional level. If you leave gaping holes, then somebody else is going to fill it for you, and I think that is what has happened. So I really encourage people in this country that whatever they are passionate about, don't just keep it to yourself, but be organized. Be organized at a national level so that you can advocate for what you feel is in the best interest of this country. You know, I am in the public service, but I try to advocate for things that I am passionate about. I don't care that I'm a civil servant. I am very mindful of where the lines are drawn, right? But at the same time, there are things that I cannot sacrifice for my family, my friends, and their children. When I'm dead and gone, what is the state of this country going to be in? Now, I wanted to speak about the Constitutional Commission, and I understand that they haven't had a chance to read their recommendations, and I will be reviewing them. But one of the things that I would like for them to be mindful of is their role to bring about public awareness.
Mm-hmm. Mm-hmm.
Yes,
It is
ma'am.
not just Mr. Maxfield's role as a citizen. They have a constitutional responsibility to bring about wide-sweeping and consistent constitutional awareness to the grassroots and general public of this country.
Precisely.
Mm-hmm.
Right?
Yes, ma'am. Yes,
so
ma'am.
things like the advisory district councils and the issues and concerns about that. The concern is not just at a constitutional level. It is also at various lower levels. Certainly, I understand that you were talking about the Alice Mako trial that was just concluded in the Court of Appeal. You know, that touches directly on the right to development, and the right to the environment.
Mm-hmm. Mm-hmm.
Now, for various reasons, I'm not sure whether they're going to be successful, and I don't think it is because of any sort of clandestine initiative. But I think what that entire process brought to my mind as a lawyer and as a citizen was the inability of the public to even understand their options in bringing a constitutional motion at an early enough point or even a legal motion at an early enough point to stop the government or to halt something where they feel there need to be more transparency.
Right.
A total and absolute lack of awareness. So I do not condemn these ladies for trying to exercise their constitutional rights. But at the same time, I believe that there needs to be a forum whereby people have an understanding of how the system works. There is a system. And we as lawyers understand the system because that's what we practice every day. But the public are the ones who have to utilize the system, particularly when they're they're challenged personally or even on a national, particularly on a human rights level. The public need to be enabled as to how do they bring actions, when should they bring actions. Do you wait until a road is built and investments have been made and the deal is signed, sealed, and delivered, or do you preempt it at an extremely early stage? You understand? So I think that there's a lot that our society has to really take stock of, and I think that we have to stop having our necks in the sand.
Yep.
My generation, the generation ahead of me, I don't know what we're doing. We must be all about making money and creating our own nest egg. But the problem is that our world is going to tumble down around us.
Yep.
Thank you, ma'am, for those comments there.
Well said, Susan.
Yep.
And I haven't seen you for quite a while, but I hope that we can get together sometime soon before it gets too late.
Mm-hmm.
Well, I just would like to leave with one last comment, and I will hang up. The last comment I'd like to make, and I know that one of the earlier callers spoke about the fact that there has been a new appointment to the judiciary, and the new appointment is not Caymanian. What I would say is that I would not necessarily blame the person who has gotten the appointment because they have advertised it internationally.
Yeah. Yes.
But it does beg the question as to why is it and what is it the country is not doing to having its own people at some point in time reaching these positions. When is Cayman going to come of age? And why is it that we are not coming of age in various areas? And quite frankly, this is something that there must be political sensitivity about. These things just don't happen in countries. They are designed and they are planned.
Yep.
For example, I work in the public sector. We cannot keep Caymanian attorneys in the public sector. And the political arm of government is quite happy. What they will do is they'll make an inquiry every couple of years in the Legislative Assembly, but they're not prepared to really look to see why is it Caymanians are not coming in the public sector. And I will say, the public sector is where you hone your advocacy skills. That is the route where most people go to become judges. It's very rare that you will be a judge if you are not a strong litigator. And what I am finding is that most of our Caymanians are not in the public sector. They're not in the courts, in the private defense bar. They are doing corporate work, which does not bring them in
the back room. Yeah,
that's right. You're right. Completely right.
Yep. Thank you very much, Suzanne, for that. And we hope you take the opportunity to call in more.
Yes.
I want to say that we could not have chosen a better and a more qualified person to be the director of the Constitutional Secretariat when we did. I know that she was wrongly accused of being partisan, in that endeavor, and that is incorrect because she did everything that she could to in those public meetings to ensure that the public understood exactly, what was happening. And I also want to say that she talks about working in the public sector, and she is one of those rising stars. Not only is she a rising star now, she is a star, and we need to see that she goes further.
That's right.
As far as the legal profession and the legal department is concerned. She's gotten to the point now where she has argued a case for the Cayman Islands in the Privy Council in the United Kingdom.
That's right, and she was the one who actually exposed me to the Cayman people at the constitutional level.
Folks, we're getting to about that time, and I'm going to ask our guests to wrap up. There's so much here that we wanted to talk about. I wanted to read an excerpt from the Caymanian Compass in 2011, 12th of January 2011, the people of the Cayman Islands are at risk of losing the hard-won democratic gains they voted for in the 2009 Constitution. Alden McLaughlin has warned, as a result of the current government's continued use of the term governor in cabinet in all of the new legislation it is passing, the former minister stated that the changes gained regarding the balance of power in favor of the Caymanian people and away from the UK's representative being undermined. McLaughlin says that he is taking up what he describes as a constitutional fiction with the Attorney General and intends to ensure that it becomes a matter of wider public discussion. Of course, we have seen those changes taking place now, and it now says the cabinet, a decision made by the cabinet. Also, we don't want, and we've spoken about the fact that the leader of the opposition has written to the constitutional commissioners in relation to his feelings on their recommendations. And I just want to quickly point out that the leader of the opposition said that, let me find that very quickly. Mr. Bush responds to Mr. Rich's letter and said that it was his view that constitutional changes should only be made by referendum except exceptional circumstances, and that the commission had not identified any exceptional circumstances. I would take issue with that and say it the other way around, that unless it is a major issue, that it should go to referendum, and any minor changes to the Constitution could be done locally. Of course, it would have to go to the UK, but we could certainly recommend and ensure that they're done locally. So again, we should not allow the political directorate, be they government or be they opposition, to commandeer this process, to be allowed to control it, so that we remain in a situation where we have a constitution that is half or three-quarters operational and the other quarter of it is not operational and is subject to not only judicial review, but changes. We didn't get an opportunity to, for instance, also to mention, Mr. McField, what you and I talked about yesterday in relation to one of the court decisions that is now legal precedent because there is no appeal, to it. And what are we going to do in our Constitution in relation to that? I'll give you, let's give Chris first an opportunity to wrap up, and then I'll give you an opportunity to wrap up as well.
Just going back to that Cayman and Compass article that you had just quoted from Mr. Alden McLaughlin, I will say this much. No one person has moved this country more backward in terms of economic independence, economic freedom than Alden McLaughlin when he bankrupted this country. I mean, that is a fact. Today, we can't even feed our children, take care of old people, or even buy a toilet paper to put in that government building without the UK say so. And in 2014, to be this far backwards from what the likes of Jim Borden and everyone fought for, and even Captain Reed fought for, to get this country moving forward, to be where we are right now, is a retrograde step and a slap in the face of Caymanian people. But at the same time, there's an old saying that says every man get the wife he deserves and every country gets the government they deserve. Cayman, we have elected some nutless people over the decades, and we are now paying for it. We're paying for it at the pump. We're paying for it at the plug. We're paying for it in the supermarkets. We're paying for it at the banks. We're paying for it at the insurance companies.
Mm-hmm. And, of course, other administrations have added to that as well.
Yeah, and it needs to stop. In this technological age, this is no longer the time for representative democracy. It's time for participative democracy. And I cannot understand a process where politicians can now go to the people. You don't need to guess what the people are thinking. You can now, in the space of a day, find out what the majority of people are thinking through technology. Politics also is a blame game. The more power you can put back to the people, the less stuff you can be blamed for. So it is beyond me why politicians in this country will not start putting back more decisions in the hands of people as opposed to keeping it for themselves and risk being blamed and voted out of office
If
after
they
one
say
term.
that they represent the people
Yeah.
and they represent the views of the people, then they should do that.
Exactly.
And don't do things because of self-preservation.
Exactly. And this is, I mean, right now, at the end of this term, we're going to have maybe 6 or 7 members in the Legislative Assembly would have an average pension of more than maybe $10,000-$11,000 a month for the rest of their lives, whether or not they serve in office another term. This is a lot of money people are getting after 16 years of service to their country. Yet, individuals like Mr. McField, who have had more than twice those years of armed service to his country, still is basically being victimized because he speaks out and on issues that are pertinent to Caymanians and are benefit to the Caymanians. They don't like it. Mm-hmm. It's as if though we must sit down and just take what it is that they say or what it is that they do. And it's because I have my own personal constitution that tells me I don't have to do nothing in life except stay fat, black, and die. I can say what it is I need to say. And who want vex can be vexed. That is my closing statement. And thanks much for my invitation. And Sean, I did behave. I did behave. Because some things that crossed my mind I didn't say.
I sort of wrote down a few things I wanted to say.
Sure.
Well, I assert that the constitutional amendment should be an internal affair of our country if all the stakeholders that agree that the Constitution needs to be amended. And it should be amended in line with the prescribed Constitutional Commissioner's suggestions. That's my position.
Mm-hmm. And theirs are not exhaustive either. You know,
they're not
there are more
exhausted.
that would come. Yeah.
They're because of the court case that just finished about the qualifications and the non-qualifications to sit as a member of the Legislative Assembly.
Mm-hmm. Mm-hmm.
That has to be clarified, and the Commission has recommended that those sections be clarified. And there's another part of the Constitution that I wanted to speak about, and that was Section 124(2)A. And it speaks to, it's Section 125(2)A speaks to the definition of public office. Mm-hmm. Mm-hmm. It says public office means, subject to Section 2, an office of emolument in the public service. And then when you go to Section 2A, it says, for the purpose of this Constitution, reference to public office shall not be construed as including references to the office of Speaker, Deputy Speaker, or elected members of the Legislative Assembly, Premier, or other ministers or leaders of the opposition. And yet the Premier was charged with corruption in public office under some law. And we are saying we didn't argue the matter because we didn't want to make the case so complicated before the jury, because that we thought that was a constitutional matter that they would probably go above their heads. They didn't understand. But the Constitution doesn't say that every public office in every other law means public office and the Premier is a public officer. And so this section has to be clarified, because truly when it says, and the Constitution is the highest law, I know that ministers are taken to be public officers in other jurisdictions, but our Constitution says that reference to public offices shall not be construed as including references to the office of Speaker, Deputy Speaker, or elected members of the Legislative Assembly, Premier, or other ministers or leaders of the opposition.
It makes it clear and it names them out. So there's no ambiguity there whatsoever. Okay. And the final words, Mr. McField?
So my final words is thank you for asking me. It's always a pleasure to come here. And I never, it's always something new every day, but not new. I'm always challenged with in why I haven't reached certain levels in our system. But everybody knows what happened. I accept the position that I'm in, and I'm getting older now. I'm not looking forward to any miracle to happen. I thank God I like you said, somebody said I have my children, and I have my son who's a brilliant surgeon at the hospital, a board certified surgeon in America, and I'm happy about that. Those things make me happy and keep going. But I'm not going to lie down and stuff. And as long as there's an issue or there's a venue to speak, I will always be here. And anytime you ask me, I'll always come.
And I will be asking you. Folks, I want to remind you that you've been listening to For the Record. I'm your host, Dorit Connor. My guest in the studio with me this morning, we had Mr. A. Steve Markfield, who just gave his closing comments. We also had Mr. Christopher Saunders. Folks, this is a conversation that needs to continue. It must continue. We cannot let this rest. We cannot put it to bed. We must have the necessary changes to our Constitution that allows for clarity, for less ambiguity, and in those instances where, because of legislative changes to the law, it means that our Constitution has to be changed as well. We need to identify them. So there must be a discussion on this. It doesn't have to be a partisan discussion. It needs to take place for all and sundry, whether or not the government does it with their caucus and the opposition does it with their members or their advisory groups, but we need it to take place. So I want to remind you again also that we are our brothers and our sisters' keepers, that there is always someone out there who's less fortunate than we are, that we should hold out a helping hand to them, especially now that we're coming up to the holiday season. We should concentrate not on what individuals want, but we should concentrate on those individuals who are in need. I also want to remind you that For the Record has been brought to you by the Auto Spa on Godfrey Nixon Way. You can receive a free vacuum with every express wash on Tuesdays at the Auto Spa. I want to say thank you for listening in. Continue to listen to Radio Cayman. Have a great weekend. Enjoy the rest of Pirates Week. Be safe and rejoin us again at For the Record on Monday morning, where we're due to have Minister Osborne Borden, talking about the health conference. Take care and stay safe. Stay safe.